Welcome everyone to the OUP webinar series. My name is Kirsten Loita and I head University Relations here at Osage University Partners. Today we are having a conversation on the new CFIUS and the CFIUS pilot program, implications for foreign and U.S. investments in startup companies. Last year, Congress passed the Foreign Investment Risk Review Modernization Act, otherwise known as FIRRMA, which significantly expands the authorities of the Committee on Foreign Investment in the United States, which is known by its acronym CFIUS. In November of 2018, the U.S. federal government began a pilot program of these new FIRRMA authorities to review, and in some cases restrict, investment by non-U.S. sources in critical technology areas. How may this affect investments by non-U.S. sources? What does this mean for university startups? And what are the effects seen so far since November of 2018? To answer these questions and many more, we have an outstanding panel of speakers with us today. Stephen Heifetz and Josh Gruenspecht of Wilson Sonsini Goodrich and Rosati, and John Lee of OUP. So you should see their pictures in front of you now, as well as some descriptions about each of them. I think many of you know John Lee, principal here at OUP on our tech investment team, but let me provide a brief introduction to Stephen Heifetz and Josh Gruenspecht, senior members of the CFIUS team at Wilson Sonsini Goodrich and Rosati. Both Stephen and Josh are based in Washington, D.C. Collectively, they have had more than 2 decades of CFIUS experience, including government service on CFIUS and in other national security positions. They have each been involved in hundreds of CFIUS matters and lead a team of national security lawyers that is particularly known for CFIUS work in the venture capital community and for the team's work in overlapping areas, such as export controls and sanctions. And I know a lot of our universities are definitely interested in those export control areas as well. In addition to advising on the large volume of transactions each week, Stephen and Josh are CFIUS counsel to the National Venture Capital Association and other parties who are interested in affecting the content of the final CFIUS rules, which are anticipated next year. Thanks for joining us, Stephen, Josh, and John.
Thanks very much, and thanks to everybody who's tuning in for the next hour or so. Just to start with some CFIUS basics, as just been said, the CFIUS is the Committee on Foreign Investment in the United States. It is an interagency committee that is comprised of multiple arms of the U.S. government, led by the Treasury Department. That's the chair of the committee. It includes the Departments of Homeland Security and Justice and Defense, Commerce, State, U.S. Trade Representative, about 10 different agencies, depending on how you count. When CFIUS started operations decades ago, the perception anyway was that it was focused primarily on investments in and acquisitions of U.S. defense companies. That long ago ceased to be, that while they that remains within its purview, the scope of their interest has broadened quite significantly, so that almost anything that warrants the label technology these days is of potential interest to CFIUS. As was mentioned just a few minutes ago, this past year, over the summer, the U.S. government enacted the Foreign Investment Risk Review Modernization Act, or FIRRMA, and at a very high level, FIRRMA does 3 things. First, it significantly broadens CFIUS's authority. We'll spend a little bit of time talking about what the authorities were and how those authorities have been expanded. Secondly, it sets mandatory filing triggers for certain types of investments into U.S. companies. And thirdly, it provides far greater resources than ever before to hunt for non-file deals, and those greater resources may be evidenced by some of the recent transactions that have been in the news with CFIUS, Grindr, where CFIUS forced divestment of a Chinese company, and Patients Like Me as another one, another recent instance involving adverse CFIUS action. The FIRRMA authorities have not been fully implemented yet. Last fall, CFIUS instituted a pilot program. Really, it's a set of interim rules that implements part of the FIRRMA authorities. Not all. Full implementation is likely to take about another year. The bottom line is that for any transaction involving any foreign person making an investment into a U.S. business, even if that investment is indirect, such as a foreign limited partner that's in a U.S. fund, really important to pause to think about CFIUS implications, whether there are CFIUS risks. It may not be necessary to make a filing with CFIUS, but thinking about whether it's necessary and how to guard against CFIUS risk is quite important anytime you have a non-U.S. person investing in a U.S. business. All right, so a little bit about the way, it's important to understand the way CFIUS operated before the new rules went into effect. Again, CFIUS is this interagency committee comprised of multiple U.S. government agencies. It has a mandate to review transactions for national security risk. CFIUS can condition an investment on what we refer to as mitigation measures. These are oftentimes, for example, limiting foreign access to the U.S. technology, putting U.S. people in certain key positions, or they can block a transaction or force divestment after closing if they take notice of the transaction after closing occurs. Until the rules issued this past fall, CFIUS was always a voluntary process. That is, it was not mandatory, at least not in the first instance, for the parties to make a filing with CFIUS. The reason they would do so is to guard against the post-closing divestment, which could often be catastrophic. And so if the parties thought that CFIUS had jurisdiction, which we'll get to in a minute, and thought that CFIUS might be interested, then they would seek CFIUS clearance in advance of closing, and that clearance would insulate them against post-closing adverse action by CFIUS. Oftentimes, usually, such adverse action was not publicly known. The CFIUS process is entirely confidential unless the parties choose to make it public, which they sometimes do if they're publicly traded companies in SEC proceedings, SEC filings. They may make it public that they were undergoing a CFIUS review. But even the fact of a filing is confidential from CFIUS's perspective. The one exception to that is if the president, who's the only person who actually has the authority to formally block a transaction or to force divestment post-closing, if the president actually has to utilize that authority, that is public. That has only happened about 5 times in CFIUS history. It's so rare because generally when CFIUS, if they decide that they have to get the president to block a transaction or to force divestment, they tell the parties that they're going to do that, and the parties don't usually insist on that action by the president. They say, okay, we will abandon the transaction or divest of our own accord, so to speak. As we said, this is a process that's focused on national security. CFIUS has the jurisdiction to reach thousands of transactions, but historically is only interested in those relevant to national security, defined fairly amorphously by reference to a long list of factors, including such other factors as the president or the committee may determine to be appropriate. So it is ultimately, in effect, up to the committee to decide whether it's relevant to national security. And increasingly, as we've said before, almost any technology has been of interest to CFIUS. Information and communications technologies, big data, energy and power, biotech, and what we refer to as personal identifier information, or PII. So the way the CFIUS's jurisdiction has been defined, it's 3 main concepts: whether there's a foreign person acquiring control over a U.S. business, and usually the linchpin has been control. This again is the way CFIUS jurisdiction has worked up to now. the new rules broaden CFIUS's jurisdiction, but this jurisdictional basis remains. So control generally is meant if the foreign investor is going to acquire more than a 10% voting stake, or a board seat, or veto rights other than veto rights that the minority stakeholder needs to protect its sort of standard economic interests. If the foreign investor has more than a 10% stake or a board seat, more than standard veto rights, CFIUS may find control. That is the way jurisdiction worked up until FIRRMA. FIRRMA relaxes the control test such that even some non-controlling investments may be subject to CFIUS review, and we'll describe that in a bit.
Okay, great. So with that background on how CFIUS has operated in the past, let's talk a little bit about what has changed as a result of FIRRMA. So enacted last August, FIRRMA is a major bipartisan revamp of CFIUS, and it's important to note, a lot of people ask the question: is this something that is unique to this administration? Is this something that's part of the general trade pugnaciousness of the sort of current outlook in Washington? And the answer is actually this has been an independent initiative. FIRRMA is something that's popular with both parties. So it's not something that that we should necessarily expect to go away after 2020. Major changes include, as Stephen touched on briefly earlier, mandatory filings for selected types of transactions, an increased focus on the transfer of American technological knowledge, particularly the kinds of emerging and foundational technologies such as AI or biotechnology or autonomous vehicles that American startups are known for. Again, the full scope of that is still to be determined, and we're going to talk about that a little bit later. There's also been an extension of CFIUS jurisdiction to non-controlling investments, as well as in other areas that are perhaps less relevant to the group of people on the line today, such as real estate purchases and leases. There's also been the provision of significantly greater resources to CFIUS, in part to go out and find non-notified transactions, both transactions that aren't notified under the mandatory filings that now exist, and the transactions that CFIUS always could hunt under its broad authorities that Stephen mentioned just a moment ago, to go out and look for any transaction in which a foreign investor acquires control over a U.S. business. Many of these changes won't take effect until CFIUS finishes the implementing regulations. That regulation writing process is ongoing. Draft regulations are not yet available, are not expected at this point into the early fall, and the full set of final regulations may not be written until early next year. But some of the new changes may be implemented on a temporary basis, according to the statute, in a FIRRMA pilot program. And we're going to talk a little bit about the first FIRRMA pilot program, which came out last November, in a little bit. So to talk about what FIRRMA allows CFIUS to do. FIRRMA permits CFIUS to impose mandatory filings for investments involving a critical technology. Critical technologies are the part of FIRRMA that was implemented in the pilot program. So we're going to hold on those for a minute and talk about them in the context of the pilot program that was passed in November. But suffice to say that a lot of FIRRMA is aimed at investments in new and exciting technologies. The other mandatory filing trigger, which is not yet implemented, is investments by a party in which a foreign government has a substantial interest. And these can be investments into any kind of company. It doesn't have to be a technology company. But the question is about the investor, whether the investor is a party in which a foreign government has a substantial interest. For example, this could be a fund in which a sovereign wealth fund is an LP. And there are a lot of big sovereign wealth funds out there doing venture investing right now. Folks like Temasek, folks like the GIC, folks like the Nordic oil funds. Those folks are involved in startup investment right now. The substantial interest test is not yet defined. It will be defined in the CFIUS regulations when they come out. But that's something to look out for if you do end up taking investment from those sovereign wealth fund-backed entities. It's also worth noting that CFIUS has in the past taken the position that many Chinese entities are subject to informal influence by foreign governments, specifically by the Chinese government. And so it is possible that depending on how substantial interest is defined, many Chinese entities, including entities that do not formally exist as state-owned entities, could be considered by CFIUS to be state-owned. We're going to watch this space very carefully. There are no rules right now. It's something that we're keeping an eye on for when the final rules do come out. So what are the risks from failing to make a mandatory CFIUS filing? Either the critical technology filings that already exist today or these substantial interest filings that are still to come. Government-imposed penalties is the most obvious one. According to FIRRMA, parties can be penalized up to the amount of the investment that they take or the investment that they make. So that means, for example, if you're raising a $20 million round from a foreign investor that you should have filed and don't, penalties could be up to $20 million for you, the venture-backed company, and for you, the foreign investor. There may also be litigation between the parties, premised on the idea that somebody failed to tell somebody about CFIUS-related risks. There may also be CFIUS intervention in the deal, which is the traditional remedy that's existed since the old regime that Stephen mentioned before. That means, when CFIUS intervenes in a deal, basically it says we want to take a look at that deal. It forces that deal to go through a CFIUS proceeding, and at the end of it, that can lead to consequences, either a mitigation agreement of the type Stephen mentioned before, or even forced divestiture, parties forced to get rid of their business entirely. See, for example, Grindr. So
I have a question on what companies or tech transfer officers should do now in terms of deciding whether to proceed with a CFIUS filing, just given that the ultimate requirements are still ambiguous at this point. So for example, if there's a sovereign wealth fund exploring an investment in a company that comes out of a university, should the tech transfer office assume that there should be a CFIUS filing for that, or how should they handle that process?
So there are sort of two questions to ask. One is whether it's subject to a mandatory filing under the rules that are in place today, which we'll get to in a minute. And those rules are precise in at least some respects. And we'll walk through how you know if you have a mandatory filing. And then the other question is if it is a controlling investment, more than a 10% stake or a board seat or substantial veto rights, then you've got to at least think about whether a voluntary filing is sensible in order to mitigate the risk that CFIUS would be interested in the deal post-closing.
There are four questions that we're going to suggest that companies ask, and we're going to talk about them in a minute with respect to that mandatory filing issue. The voluntary filing issue, CFIUS's broader authority to look at any control transaction, is more of a gestalt national security question. And one that sort of relates to generally how much of a national security interest there is in the company in question.
If you don't fall under the mandatory filing, and if it's not a control transaction, say it's a 8%, 9% purely passive investment, then you don't have to worry about CFIUS.
And we'll talk about all of that in a minute.
Got it. That's helpful.
So with respect to critical technologies, we would expect that CFIUS will continue to focus on many of the areas that it's always focused on: defense, semiconductor manufacturing, energy, transportation infrastructure, big telecommunications operators. But the rules do place special emphasis on this new idea of critical technologies, which is a set of items that are defined in the statute by a list of controlled items under the U.S. laws, the largest of which are items controlled under U.S. export control law. And U.S. export control law is lengthy and varied. It covers a number of different things. And so really, if you want to look at your critical technology status right now, the way to do that is to ensure that you understand the export control status of your technologies. In addition, there's going to be additions to the list of critical technologies in the form of new emerging and foundational technologies, which are being named right now in a proceeding that's happening at the Department of Commerce. We'll talk a little bit about the rulemaking process for that proceeding, but it's there that CFIUS is really going to start calling out the new emerging technologies: artificial intelligence, machine learning, robotics, quantum computing, or that it's called to do so in the statute through these new categories of emerging and foundational technologies. In addition to those two big changes, there are a number of other changes. We mentioned one more in the form of CFIUS's jurisdictional expansion. In addition to transactions that grant control, FIRRMA now permits CFIUS to review a number of other investments where the investor gets certain other types of rights, access to material non-public technical information about companies' products, board membership, which was already control, but also observer rights, or the right to appoint to a board, which is a little bit less clearly so, or involvement in decision-making regarding sensitive aspects of the company. What that means is that even information rights granted to an investor can trigger a CFIUS filing. And it also means that, in cases where there's a foreign LP of a U.S. fund, but that foreign LP gets board observer rights or gets access to material in the public technical information, that can trigger a CFIUS filing as well. Another big change is the direct authorization of money to CFIUS and new presidential appointees. These are the parties who are going to be forced to or charged with going out and finding the transactions that don't file with CFIUS. What this means is that CFIUS is beginning to staff up in the areas of going and finding foreign investment into any U.S. business that it deems to be of concern. And that's where you see cases like Grindr and Patients Like Me happening right now. Those cases were prosecuted under CFIUS's old authorities, pre-existing authorities. It's also where over time you'll start to see enforcement of the mandatory filing rules. That we have not seen yet. And in addition, there are a few other small changes, an expedited CFIUS declaration process that makes the CFIUS process run a little bit faster, especially for those who have to go through the mandatory filing process, and changes to the timing of the review process overall.
So Scott, a couple questions, both about who is responsible for making the filing. It is both the U.S. company and the foreign investor. So it is a joint filing made by both parties.
So just really quickly on those questions, I think one of the reasons they're being asked is because the intellectual property is usually owned by the university. It's just been licensed out, obviously, to the company that's actually developing it. And so I think some of our listeners are wanting to make sure that, whether they have obligations for that as well. But the investor is obviously investing in the company, not obviously in the university. And so I think that's where you're saying the obligation really is on the startup company as well as the investor.
That's right. It's possible that in order to make the filing, that the U.S. business may need information from the university, but the obligation rests with the U.S. company and the foreign investor.
Although one thing that we should note with respect to the licensing activity itself is that licensing activity will need to comply with U.S. export control laws. And so as a consequence, to the extent that the U.S. business starts hiring foreign persons or doing business with foreign customers, as you'll see, the changes in the emerging and foundational technologies laws may have an impact on the way that those university IP offices want to proceed when thinking about their licensing activities. So with that said,
we'll cut to the heart of it. As indicated previously, in October, CFIUS implemented two authorities under FIRRMA. First, giving CFIUS jurisdiction over certain non-controlling investments into critical technology companies, and second, creating mandatory filing obligations for those transactions. And then relatedly, CFIUS put into place a streamlined filing process when the parties are subject to those mandatory filing obligations. There were hopes that streamlined filing would substantially reduce the burden for the parties. Sometimes it works out that way, but not always, for a variety of reasons. Sometimes the parties end up, after doing the streamlined filing, having to make a longer form filing. Traditionally, CFIUS filings took a few weeks to assemble and many months for CFIUS to review. The streamlined process is about 45 days, but sometimes at the end of the 45 days, the parties have to file the long form notice. As noted earlier, there are penalties for failing to make a mandatory filing up to the value of the investment. And those penalties could be levied on the U.S. company or the foreign investor or both. All right, we generally said there are 4 questions that you need to ask to determine whether you have a mandatory filing. Again, as a reminder, even if the answer, this is a conjunctive test. So if you answer no to any one of these questions, then you don't have a mandatory filing. But as a reminder, if it is a control transaction, if the investor is acquiring control, then CFIUS could have jurisdiction. They could intervene and ultimately force divestment, even if it's not a mandatory filing. Okay, the first question is, do you have a foreign investor? And a foreign investor is a foreign individual or an entity or a foreign government or a U.S. entity that's under the control of any foreign person. A U.S. fund, if it were managed by, had a general partner that is foreign or comprised of foreign personnel, CFIUS likely would view the fund, even though a U.S. entity, as under the control of a foreign person and therefore foreign. Furthermore, if you have a U.S. fund that has foreign limited partners, though CFIUS could view the limited partner as making an indirect investment in the U.S. portfolio company if the limited partner has certain triggering rights, which is the second question that we have here. Is the investment one of the types covered by the pilot program? And in particular, does the investor, whether a fund or a company or a limited partner in the fund, receive any one of 4 triggering rights? Those triggering rights are control, as we've defined it previously, or a board seat or observer seat or the right to nominate somebody to such a position, or access to non-public technical information about critical technologies, or involvement in decision-making about the U.S. company's technologies. So any one of those 4 triggering rights gives rise to a yes answer to this second question. Again, this is a conjunctive test, so of the 4 prongs that we're going through, you have to, if you answer no to any one of the 4 prongs, then you don't have a mandatory filing. But on this second prong, any one of those triggering rights gives rise to a yes answer to the second prong. So the first 2 questions have focused on the foreign person and the rights of the foreign person. The next 2 questions focus on the U.S. company. The third question here is, does the U.S. company deal in critical technologies? As mentioned briefly earlier, critical technologies is defined by reference to U.S. export controls, and in particular, a list of 6 different lists. So to determine whether it's critical technologies, you got to find it on these, find the technology on the list and see how it is coded. One of those lists is hundreds of pages long. 5 of the 6 lists are more or less fixed. You can determine whether you are on 5 of the 6 lists. The remaining list, which is the emerging and foundational technologies list, is currently the null set. The U.S. government is in the process of designating emerging and foundational technologies. They haven't designated any yet, but when they do, those emerging and foundational technologies will become critical technologies and therefore expand the scope of transactions for which CFIUS filings may be necessary. The fourth prong is, if there is a critical technology, is that critical technology being utilized in or designed for use in one of 27 industries that CFIUS has designated? These are things like biotech R&D, electronic computer manufacturing, navigational services, and lots of others. It is important to note that questions 3 and 4 are distinct. If oftentimes folks look at the list of 27 industries, which includes, as we've said, biotech R&D, and they say, oh, we do biotech R&D, therefore, if we have a foreign investment that gets one of the triggering rights into our biotech company, we have a mandatory filing. Not necessarily. It depends on, you have to hit all 4 triggers, including critical technologies. And oftentimes, biotech companies, it turns out, when you look at the export control lists, their technologies are not always codified in a way that makes them critical technologies under the current definition. All right, we've noted that the critical technologies list is going to be expanding. In November, the Department of Commerce began a proceeding saying, hey, we're looking at making designations in areas like biotech, artificial intelligence, quantum computing, robotics, and the like. Let us know, public, if there are other areas that you think we should be looking at. We are eventually going to be making specific technology designations in some of these areas. They have not done that yet. They are expected to do that within the next year or so. And again, that will expand the realm of critical technologies and therefore the realm of mandatory filing obligations. It separately will expand the realm in which it may be necessary to get export control licenses if you are exporting product or technology, which includes putting it online, and even having foreign nationals with access to that technology in the United States. That's often referred to as a deemed export. And once they define new critical technologies, it is quite likely that export control licenses will be needed in some circumstances if you have, for example, a lab with foreign nationals that are now having access to those emerging technologies.
So we received a question with respect to what the 5 to 6 lists of items that are currently covered as critical technologies are, and whether the Commerce Control List was one of them. The answer is yes, the Commerce Control List is one of them. The Commerce Control List is the list designated by the Department of Commerce under the Export Administration Regulations. It's not everything covered by the Commerce Control List, but it's a large chunk of that list. That list is the biggest single part of the list of critical technologies. It runs to the hundreds of pages. The other lists include the International Traffics in Arms Regulations, which are the regulations maintained by the Department of State for military-related items restricted for export, 2 different lists of nuclear-controlled technologies, and the list of select agents and toxins maintained by the Centers for Disease Control. Those are the 5 current lists. The 6th list is, of course, the emerging and foundational technologies categories, which are in the process of being designated now.
On the Commerce Control List question, as Josh said, it is not everything on the Commerce Control List. Anything that is EAR 99 for those export control mavens out there, that would not be critical technology, generally speaking. And there are lots of things on the Commerce Control List that, for example, things controlled only for anti-terrorism reasons. That's not critical technologies, but unfortunately it really requires an analysis at the very granular level to determine whether it is constitutes critical technology.
And Josh and Stephen, I imagine we can, after the webinar, provide all of our attendees a link to the lists themselves so that they have that information.
Sure, yeah, I mean, we can send you, and you're more than welcome to contact us, and we have lots of CFIUS and export control information that we can provide. But the Commerce Control List is a Department of Commerce promulgated set of regulations that is available online, and we can certainly point you in that direction.
Terrific, thank you so much.
No problem. So then the next question for many people is, well, what do we do about all this? And so, you know, with respect to folks who are taking investment right now, we see a lot of investments, probably upwards of 50 a week, with various different outcomes. Many of those don't have to file. Others of those avoid filing through structuring mechanisms. Many of them end up filing. So what are the strategies for living under FIRRMA? Excuse me. So I think that the baseline point, and it's one that we made at the top, is that it probably does make sense if you are taking an investment from a foreign person and you are a U.S. business, or if you are a foreign person making an investment into a U.S. business, it probably makes sense to take a moment to stop and think about whether there's a CFIUS problem. It is often the case that there isn't one, but given the breadth of this new regime, it's worth just taking a moment to breathe and understand the question. The analysis probably should occur early. It is a lot harder to unscramble an egg, and risks can be allocated to counterparties through legal agreements. We do a lot of this. So for example, if you are a U.S. business and you're concerned that you don't know the provenance of the fund that's considering investing in you, you have no idea who their general partners and more possibly even less of an idea of who their limited partners are, there are things that you can do. For example, you can seek a representation from them that they are in fact a U.S. entity. You can use waivers of liability or indemnifications to assign liability directly to one party or another. There are a lot of legal language tools that you can use to move CFIUS-related risk around. The risk of CFIUS intervention in non-filed investments is not new. The old voluntary regime has been around for a long time. It's still there today, but the likelihood of intervention will be higher because of the increased resources that we mentioned. Mandatory filings that are not made will court CFIUS penalties. Eventually, the group that is responsible for CFIUS enforcement is still being stood up, but when it stands up, that group will be responsible for looking at investments, both present and past, that are of concern. As again, we've seen, just to go back to the recent examples, Grindr and patients like me, CFIUS is willing to look back a year, 2 years, to see if there's an investment that it wanted to catch that it missed the first time around. And because it does not have a statute of limitations on its authority, it will step back and take a look at investments, possibly to the extent of unwinding those investments if it views that as necessary for national security. So what do people do then? Why do people file? Why do people not file? How do people make those choices? The main reason that people have concerns about filing is because of their investment timelines. The general practice at CFIUS has been to file with CFIUS shortly after signing and close after clearance. But clearance can take a long time. The new short form CFIUS process that is available to those folks who fall under the mandatory filing regime has been clearing out cases within sort of 30 to 45 days. The older long form filing regime that's been around for a long time tends to run significantly longer than that, 3, 4, 5, 6 months. And it is the case that it is possible that a short form filing at the end of those 30 to 45 days is asked to enter into a long form filing. So it's possible that there's a long timeline in some cases for CFIUS filings. For that reason, a lot of people want to find a way to work around those timelines because they need to get their businesses funded. Foreign investors and U.S. businesses have developed a lot of strategies for that. One of the primary ones is two-stage transactions. Two-stage transactions are those in which the foreign investor puts its money into the company immediately and gets a set of rights that would not trigger CFIUS filing, and then goes through the CFIUS process, and at the end, when clearance is obtained, they convert into the set of rights that they require. This can be done in a lot of different ways, using convertible notes, using non-voting stock that converts into voting stock. There's lots of different options, different implications. Transactions of this type have to be structured carefully to make sure that CFIUS does not view the initial first stage investment as granting control, but it's a very popular mechanism for people who want to seek investment and they want to seek it from parties who do need to go through the CFIUS process. Another thing that parties often do is limit the rights granted to the foreign investor, so there is no obligation. As Stephen mentioned, the mandatory filing program is triggered by control, by access to material non-public technical information, by substantive decision-making rights. If the foreign investor gets none of those rights, then the foreign investor doesn't have a filing obligation. And so an investment that's structured in a manner to avoid giving the foreign investor those rights is an investment that can avoid the need to file a CFIUS. However, control is a pretty gray area, and parties have sometimes have fights over what rights the foreign investor can and can't have. And another very popular option is to take a look at the business of the U.S. company and determine that there are no critical technologies at issue. And if there are no critical technologies at issue, then there's no need to make a mandatory CFIUS filing. However, the set of critical technologies is still in flux, so That may not be a permanent solution for all companies, especially those in exciting, advancing areas like AI and robotics. And it's also the case, of course, that under CFIUS's old voluntary authorities, you don't need critical technologies to get CFIUS involved. So with that said, I think we will turn it over to John to talk a little bit about what in the market people are seeing with respect to foreign investment.
Thanks, guys. Yeah, and so in the market, I would say that anecdotally, we've seen a range of different outcomes come out of FIRRMA. In some cases, we've seen companies set up separate Chinese subsidiaries to avoid foreign investment into the company. In other cases, we've seen some venture capital firms disband because they no longer really had the ability to invest in the U.S. without triggering a mandatory CFIUS review. And then additionally, we've also seen a flurry of activity happen before FIRRMA was formally established or started back in November. And so this graph here is a graph by month of the dollars and the number of deals that foreign parties executed in investments in U.S. companies. And so the blue bars represent the amount of dollars, and the red line represents the amount of deals that have been done. As you can see, the October-November timeframe, there was a bump in activity around both dollars and deals for foreign investments in U.S. companies. If we flip to the next slide, the most meaningful impact that we saw was actually on Chinese investments into the U.S. companies. And so in November, we saw kind of a record amount of investments by Chinese investors into U.S. companies, but dying shortly after that, both in dollars and number of deals committed. And I would say that anecdotally, we've seen this in the market as well, where there are a lot of growth stage financings issued by Chinese companies. We've seen virtually a dearth of those since November. Moving on to the next slide. This slide indicates the top 25 foreign investors in U.S. companies. And so the first column is the top 25 investors into U.S. companies over the last 6 months. Here I've highlighted the Chinese investors in this column. And then the next column, the middle column, is the top 25 Chinese investors in the last into U.S. companies in the last 6 months. None of these investors are actually represented in the top 25 foreign investors in the U.S. If you compare that to 2 years ago, there were actually about 5 Chinese investors that were in the top 25 foreign investors in U.S. companies in the last 2 years. And so you've seen a noticeable drop of Chinese participation in late stage financings or even early stage financings in the United States.
John, I have a quick question for you on that. That's been an overall, have you seen that be a large overall impact on investments in U.S. companies, or is it, do you see it as somewhat negligible?
I would say that in terms of late stage financings, the Chinese investors and foreign investors were a great source of pretty substantial growth capital. At least I would say case by case in the companies that we've invested in, no longer are those avenues really an opportunity to raise financing from. So I imagine that going forward, it'll be a pretty large impact on late stage financings for venture capital firms, perhaps meaning that perhaps meaning that startups can't stay private as long, or they have less options for late stage financing.
Great, thanks.
So I think we got a question with respect to the two-step investment strategy. And the question was, how is it legal for an investor to limit their rights to allow them to make an investment before they get through CFIUS, but then award them those rights after they clear CFIUS? And the answer is because the CFIUS applies to foreign investors who get a certain set of rights. So if you give somebody money before you get those rights, then you're not exceeding the thresholds of CFIUS control that CFIUS is concerned about. And then if you wait for CFIUS clearance and then take those rights, then you've adhered to the CFIUS process.
And the policy underlying that is that in general, U.S. government welcomes foreign direct investment, and passive investments, the national security establishment generally doesn't have concerns about. When there are certain rights associated, then it's non-passive and there may be concerns. So the notion is you defer the rights that make it non-passive until CFIUS has approved it.
Great, thanks.
Another question, what should U.S. universities, considering technology licensing from to a foreign company, does FIRRMA, does CFIUS apply in that context? In general, if it is simply a license of technology, CFIUS generally does not have jurisdiction. If the license were such that the U.S. company no longer has any value, say it's an exclusive and worldwide license and there is nothing effectively left of the company, it is possible that CFIUS would say, well, that's a sale by any other name, and exercise jurisdiction in those contexts. But in general, just a licensing transaction should not give rise to CFIUS jurisdiction if it's not, doesn't deprive the U.S. company of all value, and if it's not coupled with some other transaction with the foreign investor. CFIUS will aggregate transactions. So if you had a licensing transaction and then a separate equity transaction, CFIUS would aggregate those things if they involve the same foreign investor. But licensing in and of itself shouldn't give rise to CFIUS jurisdiction.
Okay, great. So I have a couple of other questions, and I'd like to encourage our audience, since we still have some time left, if you do have some questions, there is a Q&A box down at the bottom. Feel free to type in some questions there. But Josh, Stephen, and John, one of the questions I have is, and I think I know the answer actually now that I've heard your presentation and you've gone through all those different the steps and the types of filings that are needed. But just so our audience hears the answers to this, what are the implications for venture capitalists, venture capital funds, as well as university venture funds that already have raised funds that have non-U.S. investors, where they still need to make capital calls and are getting money in from these non-U.S. investors? Are there implications with CFIUS with regards to this?
So it's going to depend, the CFIUS implications will depend on the particular investment into the portfolio company. But certainly, to the extent that there are foreign limited partners, as laid out here, it's possible that CFIUS would have jurisdiction over a fund investment in a U.S. company. These mandatory filing rules do not apply to transactions that closed prior to November 10th, which was when the rules became effective. So those, and furthermore, to the extent that there are follow-on transactions that are just pro rata investments, CFIUS has said that will not trigger a mandatory filing. But funds that have foreign limited partners or that have foreign participation, foreign management that are making investments going forward, depending on, they may be subject to CFIUS jurisdiction, either the voluntary regime, if the investment gives rise to foreign control, or mandatory if it hits the 4 triggers that we discussed.
Right, and also just one point to note there, with respect to the investment that has been taken in the past, it may be the case, depending on what it was in the past, that previous investment had, could have been triggered, could have triggered CFIUS jurisdiction under the old voluntary rules. And so, there's always the possibility that CFIUS comes and knocks on the door of the startup in question and wants to take a look at the previous investment, whether or not there's actually a capital call happening. But that would only happen in cases where CFIUS sort of both caught wind of the investment and viewed the company in question as raising certain national security issues.
There is no statute of limitations for CFIUS. They can look at a transaction anytime, including years after closing. Generally, it happens within a year or so of the closing.
So we've seen a bunch of questions pop up since Kirsten asked for them. The first is, if a foreign organization funds research at a university and the terms of that research agreement say the foreign organization should receive equity in any U.S. startup that licenses the resulting technology at the U.S. university. Is that foreign investment, and does it trigger the pilot? So the answer to that is, historically at CFIUS, there's been an informal exception. It's built into the old CFIUS rules, known as the Greenfield exception, that says that, sort of foreign investment that gets into a company at the time the company is starting up is not really considered to be foreign investment. It's getting a new company off the ground, not investing in an existing U.S. business. That's an informal, not a formal rule. And so, CFIUS may choose to apply it or not apply it in certain circumstances. But generally, we don't think of investment that's accepted at the very beginning of a company's founding as the kind of investment that gives rise to CFIUS liability. Because CFIUS has very broad authority to determine its own jurisdiction, because it's very difficult to get out from CFIUS into the court system, so there's very little oversight of the CFIUS process. That advice has to be taken with a grain of salt in cases where the technology might be really, really sensitive. But generally, we don't think of equity granted at startup as the kind of equity that triggers CFIUS liability.
Great.
A couple other
do you want to go to the
questions?
next question? We do have quite a few, so.
Yeah. Sure. So the question is, would you have to file with CFIUS for a tech transfer office licensing to a foreign-owned company? As we said, if it's just a license, probably not. If the license is accompanied by other things, particularly an equity investment, CFIUS could aggregate those transactions. But if it's just a license, that is probably not going to give rise to CFIUS jurisdiction.
Right. One thing to note there with respect to FIRRMA is that the non-CFIUS part of FIRRMA, i.e. the sort of export control expansion into emerging and foundational technologies, may expand the number of items for which you would have to seek an export control license in order to license them to a foreign university. But that's outside of the CFIUS process. That would be a traditional export control license that you might have to seek for a new set of categories of technology.
Good. So another question: of the filings that we've been involved in since this November, what percent stretch past the normal window? The normal window being you've got to file 45 days before closing, and CFIUS may take a week or two to accept the filing, and then they have to turn it around in 30 days. The short answer to that is about a third. Our anecdotal information is that in about a third of the cases, CFIUS is telling the parties they need to file a long form notice. When CFIUS gets to the end of their 30-day process, they have to produce a response, and in about a third of the cases, they're telling folks, you got to make the long form filing. In another third of the cases, CFIUS is saying we didn't come to a definitive conclusion, which allows the parties to close their transaction, but also reserves the right to CFIUS to force a long form filing down the road. They generally don't do that. If they wanted the long form filing, they would ask for it, but it at least gives them the right to ask for it. So when you're doing the financing documents, it is important to specify what, if you're going to make a CFIUS filing, whether the condition to closing is a full clearance or whether what we refer to as a shoulder shrug, and we didn't reach a definitive conclusion by CFIUS, whether that's sufficient to satisfy the closing condition. Obviously, if CFIUS says, hey, you need to make a long form filing, then that's generally what you have to do.
Right. But so what that means sort of timing wise is that 2/3 of cases can be concluded within 30 to 45 days has been our experience thus far. It's also the case that part of that other third, the third that are asked to make long form filings, is a set of investors who've decided to be ultra cautious, who have elected to make short form filings, even though I think all parties with relatively significant CFIUS experience would recognize that they're difficult cases and they're cases that probably should file the long form filing to begin with, but the investors have elected to file the short form filing anyway. If you're just talking about cases that, that we generally view as pretty low risk, which is a lot of foreign investment, a lot of those investments can be completed in 30 to 45 days.
Terrific. I have one final question before we close it out, since we don't have any remaining questions from our listeners. Could you talk a little bit about the costs associated with these filings? Obviously I believe there's a filing fee associated with this to the government, et cetera.
So I'm glad you asked that, because there is a common perception that there is a filing fee, and so far anyway, there is no filing fee. The FIRRMA did give CFIUS authority to create a filing fee. They have not done that. Their authority is a filing fee up to 1% of the value of the transaction, or $300,000, whichever is less. But they recognize that that would be a very big deal to create that filing fee, and they have not done it. We have not heard any rumor that that is on the horizon. So the fees are legal fees. For a declaration, for the short form filing, we've typically been running in the 15 to 20K range to run through the process. Depending on how that process goes, it could be more, but typically to get to the point that CFIUS has accepted the filing as complete, runs anywhere 15 to 20K. Once you've done there is a template that CFIUS has online. Once you've done one of them, I think it gets easier. So, sometimes companies have reached out to law firms, ours and others, for help with the first one, and then done others on their own.
Right.
Well, one thing to note for folks who are, in the business of raising a Series B or a Series C, and they've got a collection of investors, is, and we get asked this a fair amount, do we need to make 5 filings because we've got 5 foreign investors? The answer is no. Make 1 filing, incorporate anybody who gets the kinds of rights that are a problem. It's not like you just, need to submit a pile of these things. It's really just, 1 filing for the capital raise where the investors' rights change.
Terrific. That's good to know, and it does actually clear up, I think, definitely a misperception, and maybe some worries people especially had when the pilot program was implemented. So that's really helpful. We had this question a couple of times about the slide deck. Yes, it will be available to everyone who registered for the webinar. We actually have recorded this as well. That recording will be provided to everyone who has been listening as well. So before we wrap up, we would love to collect everyone's feedback on the webinar. You'll notice a link to the feedback survey that's going to be in your chat box right now. If you could fill this out, we would really greatly appreciate it. Your responses help us determine any changes that we make to our webinars, plus future topics that we'll cover. So please do fill out the webinar survey. It's very short. Thank you so much. Josh, Stephen, and John, thank you so much for your expertise and time today. I think this has been an incredibly formative webinar, has really helped clear up probably a lot of people's concerns around what's been happening around this area. So thank you very much for your participation today. It was just terrific. And to our audience, if you have any additional questions for Josh, Stephen, and John, please reach out to them to the email addresses you see on this slide. They are happy to answer any further questions that you may have. Obviously, they've been working very heavily in this area for a while now, especially Stephen and Josh. And I know that this has been an incredibly busy time, so we really value that they were able to take some time with us today on this topic. So thank you, everyone, for your participation in our webinar, and enjoy the rest of your day.